Well, hello out there, everybody. I'm Debbie Davis, and welcome to the live stream about the Michigan Child Custody Best Interest Factors. So, obviously, this is geared toward people that have custody or parenting time, divorce things in Michigan, but I think it's probably good information for anybody that's going through a custody case wherever you might be. So, let's get started. A little bit of background. I did divorce and custody work since 2007. So, kind of a few years under my belt doing these. I did all sorts of divorces, paternity cases, that sort of thing. So, from that, I've kind of learned some tips and tricks that I think, as either practicing attorneys or people going through their own cases, you might really gain some benefit from. So, let's get started. I'm going to share my screen for most of this probably. That way you can kind of see what I'm looking at. So MCL 722.21 is the start of the Child Custody Act of 1970. Yes, it's been a minute since they've updated this, but that statute is still the controlling statute for these issues. If you look at the third section down, 722.23, the best interest of the child defined. This is the holy grail of all custody and divorce cases involving children. So when you're looking at what the term best interest of the child means, it is these 12 factors. And I'm going to share another screen that kind of has a breakdown of what these factors are, because they're kind of confusing when you just read through them, like the love, affection, and other emotional ties existing between the parties involved and the child. Well, what exactly does that mean? So with that, I'm going to switch then to this document. This is what I have developed over the years, of course, with the help of my mentor, father-in-law, years ago. And it's my cheat sheet. This is what I send to every client that was even considering filing a change of custody if there was a post-judgment divorce action, or a divorce with minor children where there's an initial custody determination. Anybody that was looking at custody, they had to look at this form, and they generally would fill it out and send it back to me. So with this, number one, the court, in changing custody, if it is already established in a custody order, if the parties weren't married but went through the court process, or just stipulated to an order regarding custody, that is one way that it's set, and that's an order. That's what people have to follow. The other way is if a court orders it through a divorce, through a trial, or whatever the case might be. And anytime that there's a judgment entered that establishes your custody, you cannot change that without certain standards being met. And the standard is, if there's an established custodial environment, then if you want to change custody, you've got to prevail on a majority of these factors by clear and convincing evidence. Now, if there's not an established custodial environment, maybe it's the initial divorce that you're trying to decide, then if there's an established custodial environment with both of the parents, then it's a preponderance of the evidence. And more likely than not, that you're going to prevail on a majority of these child custody best interest factors. Now, a lot of people get confused about this because this isn't like one or the other. Some of these factors are going to be fairly equal with both parties. So let's get into it. If we scroll down, number one, as I had said, the love, affection, and other emotional ties existing between the parties involved and the child. So with this, the court's looking at, who does the child bond with more? Who does the child approach with a problem? Who empathizes more with the child? Who spends more hours per day with the child? And who prepares the child's meals? Who bathes or puts the child to bed or reads them stories? Who has the ability to separate their needs from the child's needs? And to whom does the child openly show signs of affection? Now, this gets a little sticky at times because you have more than one more than one child in a home. So you're really looking at the factors for each of the children. So a lot of times if a parent comes in and they have more than one child, they will specify, all right, well, This child is an infant and it's still breastfeeding. So that child is obviously going to be more bonded or more closely attached probably to the mother if the child is still breastfeeding. Whereas if you're talking teenagers or preteens, sometimes it's a crapshoot. Maybe neither of them are really super close and affectionate with the child, right? It just depends on the child and on the family dynamic. Moving on to the next one. The capacity and disposition of the parties involved to give the child love, affection, and guidance, and to continue the education and raising of the child in his or her religion or creed, if any. So, what does this mean? Who stays from home if the child is who stays home from work if the child is sick? Who's taking responsibility for the educational matters? Who is responsible for involvement in extracurriculars? Who disciplines the child, and how do you discipline the child? Is there verbal abuse by either of the parties? And does one party enable extended family involvement more than the other with grandparents, uncles, aunts, and others? And who involved or might involve the children in a religious creed? So let's kind of break down a few of those. Just because you're not the one that is staying home when the child is sick doesn't mean you're going to lose on this factor, okay? A lot of families have two parents that are working, and both of them are kind of sharing the responsibilities of the educational matters and the extracurriculars. So a lot of times, you want to showcase what you are particularly doing, maybe better than your spouse or more frequently than your spouse, if you want to prevail in this factor. As far as discipline, this doesn't mean that the judge is taking a stance one way or the other on what we would call corporal punishment or spanking. If both parties are using that same method and they both agree on it, that's probably not going to be an issue for the judge. If there's a strong opposition to corporal punishment and one parent is using it and the other isn't, then the judge may consider that. Obviously, verbal abuse, huge issue. If it's verbal abuse of the child, that certainly is going to play into the judge's decision on who should have custody of that child. The extended family component is kind of interesting. I've had several cases where the parent that I'm representing is willing and able to facilitate a relationship with the other side's grandparents, which is really important because even if it doesn't work out with your spouse or your significant other that you have a child with, that child still deserves to have a healthy relationship with the parent and their extended family. So I have had cases where the other parent maybe isn't close with their own parents and the grandparents, and they don't let the child see those grandparents. And I've had my client then prevail because they allow their child to go with their ex's grandparents, like all of that extended side of the family, whereas the parent on that side wasn't allowing it. So certainly that's something that the court takes into effect, that you are willing to look at what is best for your child, even if it's uncomfortable for you, whether you're uncomfortable with the grandparents or you're uncomfortable with your ex-spouse knowing that you're sending the kids with them, but that you're doing it because it's best for the kids. As far as religion, there's not a specific religion that the judge is obviously going to favor or anything like that. But if one side has been taking the kids to some sort of religious services regularly and the other side doesn't, or the other side opposes it, it may become an issue. Next. Factor 3, the capacity and disposition of the parties involved to provide the child with food, clothing, and medical care or other remedial care recognized under the laws of the state in place of medical care and other material needs. So what does that mean? It means who's making the purchases for the child, who's attending to any of their special needs, who has a greater earning capacity. We'll get to that one because that's a little tricky. Who is able to adjust their working hours based on the needs of the child, who has a better certainty of future income, who can provide health insurance, who takes the child to the medical appointments, who arranges for childcare. Again, we're looking at the totality of everything in the relationship, and whether it's an infant child or a 17-year-old, all the way up until they're 18, they're considered children that would be subject to these child custody best interest factors if the parents were to split up. So in making purchases for the child, we're not talking about who's going to spend more money on the kids and spoil them. We're talking about who in general is the one that is purchasing the diapers, the wipes, the formula, or the one that is purchasing their clothes. Do you know what size shoes and clothes your kid is wearing? That often becomes a sticking point where one parent says, well, you've never bought a single stitch of clothing for them. Do you even know what size they are wearing? You better know what size your kids are wearing if you're in a custody battle. As far as the earning capacity, it's not just that whoever earns the most is going to get the kids, right? That's not how that works. But if you have a parent that has never worked outside the home and now wants to go work outside the home, or maybe has to go work outside the home because there's a split in the relationship and they have to start being able to support themselves, you have to look at what type of job is that person going to be able to get, and are they going to be able to adjust their hours now that they're just getting back into the workforce? They may not have the flexibility that the other parent has that has been in the workforce for some period of time. As far as scheduling and taking to the medical appointments, you better know who your kid's doctor is and where they are and when the last time they've been there, because we've had clients get burned on that on the stand when a simple question, well, who's your child's pediatrician? And if you can't answer that, you are going to get a black mark on your column that the judicial fact finder is looking at if you can't figure out who they are. Some didn't know their children's birth dates. So also, those are important things that you need to know. So preparation. If you get to the point where you're at a hearing, you better have memorized all of these things. And arranging for childcare. I mean, obviously, if it's a teenager or something, that one's not going to be taken into account. Okay, the length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. So what does that mean? Well, who has provided up until trial and who can provide in the future a stable, secure, safe environment? Who can provide that continuity? So this one is more so for, I look at it as most important in a post-judgment custody case, because if you're looking at an initial divorce case or an initial custody case where the parties were living together until they filed something, then really they're very equal on who has this continual, safe, secure environment, assuming that there's not, domestic violence, something like that. We'll get to that one in a minute. The continuity, though, I look at this factor in post-judgment cases as being one of the key factors. Because if you're going to uproot this child and take them out of one custodial environment and put them into another, like flip-flopping custody or something like that, then you want to make sure that you can show that it's a safe, secure, stable environment. You're not moving constantly. You don't have boyfriends or girlfriends that are coming in and out, switching relationships, often that sort of thing. So it's very important that, if this is a post-judgment, you be honest with yourself and honest with your attorney about what your living situation is. If you have a full-time live-in person, even if you're not married, you have to be honest about that to your attorney and make sure that that's going to be an environment that the court is going to look at and say, this is a safe, stable, secure environment. Moving along, number 5, the permanence as a family unit of the existing or proposed custodial home or homes. So again, this one is not so much for divorce cases. This one is more so for post-judgment. So in whose custody will the family unit not be split? This is one where we would bring up any half siblings or step siblings that are close with the child. So there are times where if the parent post-judgment again has remarried or moved in with somebody and the children get along really well with their new step siblings, half siblings, or just significant others' kids that don't necessarily have a title at that point, the court does look at that, and splitting up kids within their own family unit is also something that's not done very often. So you're talking sibling groups that have the same mom and dad. It's generally frowned upon to split them up. I'm not saying it never happens, because it has before, especially if we have kind of toxic relationships between siblings for whatever reason. The court has made rulings, or the parents have agreed to split those siblings up into separate homes. Number 6, the moral fitness of the parties involved. So this one is where it gets a little hairy for people, right? This one's talking about, have there been extramarital affairs that are known by the child? Has there been any physical or verbal abuse, alcohol or other substance abuse, drug abuse, poor driving records, physical or sexual abuse of the kids, criminal records, or other illegal or offensive behaviors? Now, people want to throw dirt, right? It's like their first initial strike is, I want to tell the judge all the dirty, terrible things that this other person has done. The problem is all of these custody best interest factors, these are something that you would have to prove by evidence. Now, evidence can be, raise your right hand, swear under oath, and tell me the truth about what you saw, heard, tasted, felt, whatever, smelled. And that is evidence. However, if you are looking to use these issues and you don't have some other physical evidence, or you only have hearsay, which is something that someone told you, and if you repeat that in court to prove the truth of the matter asserted, it's going to get excluded. So it can't be that you just think that it might have happened, or so-and-so told you that it happened. Even with text messages, Facebook messages, Instagram posts, whatever it might be, those are really hard to prove. We can present copies of text messages, copies of pictures that they posted online, but things can be taken out of context. And the court will generally, if you can lay a foundation for where you got that item from, they will take it into consideration, but it's not a be-all, end-all. It's not like the smoking gun, right? Unless you have something where it's them tape recorded, saying it, then you got something. But text messages could be sent by anybody. It could be their spiteful significant other that's sending you texts from their phone. You really don't know. So there, you have to kind of temper that with, do I put this out there? Well, I can, but is it going to do more harm than good in the long run with your custody case? Okay, moving down. Oh, and I guess going back to that one, the judge has to assess whether this dirt that you have on your ex is actually something that is going to negatively affect their parenting or influence the children or negatively affect, their parenting skills. So it's not just, okay, they did it, they cheated. Okay, not a good thing, but unless you can show a direct impact on the kids or, something that's more than just they made a poor choice and now here we are, then, it may not be worth it to bring it up in the court. Number 7, the mental and physical health of the parties involved. Does either party have a physical or mental health problem that significantly interferes with their ability to care for the child's well-being? And this also looks at the age of the parents compared to the age of the child. Most parents, the age thing isn't going to be an issue. The mental and physical health, though, can be. So if you have a parent that has a chronic physical condition that is dangerous for the child to be alone with that parent, they may not have custody, and their parenting time could even be restricted and made to be supervised in some manner. I've had cases in the past where a parent had a traumatic brain injury and it didn't make them incapable of caring for the child, but the safety plans had to be put in place to make sure that if something did happen, there was somebody there that could assist. And again, you're talking infants and toddlers versus a high schooler. Certainly it's a very different situation, and the court looks at that situation too. All right, moving down, the home, school, and community record of the child. So who is encouraging and influencing the child to attend school? Who is actively involved in their conferences and activities? Who can adequately assure the child's access to friends and peers? Who can supervise the child's home responsibilities? Who takes responsibility for completion of school assignments? Who can reduce the necessity for any involvement of juvenile court? And it's not called FIA anymore. Let's see how old this is. DHHS, like your Child Protective Services. So this one, Obviously, with an infant or toddler is not going to be your main factor that you focus on. This one is the main factor you focus on with older kids, though. Any school-age child, you would want to make sure that you are making sure they get to school on time. If that's one of the biggest issues that I see when there's parents jockeying for who's going to have custody is the child tardy all the time with you, or just not going to school. We've had that situation where they become truant because they haven't been in school. If you're the parent who for 10 years never went to a single school conference, you better start going now if you want to stake your claim for some custody. Adequately assuring the kids access to friends and peers, that one's a bit dicey because with COVID, I mean, obviously things have changed a little bit, but you want to make sure that you are presenting to the court evidence that you know who your kids' friends are and who their parents are, and you can make sure that they're going to have access to those friends for their own mental health and emotional well-being, even if you're moving to a different area, whether it be across town or to another town, whatever the case might be. And also looking at that, kind of going back to the continuity portion too, if you are moving somewhere where the child or children are going to have to switch school systems, the court is going to look at that very carefully, because if the child has already been involved in a school system for 1, 2, 3 years, they're pretty invested in that school system with their friends and peers and teachers, and the school certainly would not want to lose them in most cases. So the court is going to look at that carefully if there's a change of custody that would disrupt that school environment. Number 9, this is the one that people are always asking questions about. The reasonable preference of the child if they're of an age to give that preference. How is this done? Well, number 1, what is the age to give a preference? It's really child dependent. We can have some 9 and 10-year-olds that are extremely precocious and they are well spoken and they can go in and speak with the judge and give their reasons without showing any sort of, coaching or something like that. We have 14, 15-year-olds that are not maybe as mature, and they can go in and talk to the judge, but it's going to be, sorry if it's boring for some of you, I know. I told you, this custody stuff is not for everybody. If it's a 14 or 15-year-old that is going to go meet with the judge and they want to go stay with mom or dad because mom or dad lets them smoke weed and drink and have their boyfriend or girlfriend stay the night, that's a different issue. So the preference of the child, generally by age 13 or 14, the court will look at what they have to say. Now, this isn't done where this kid is put up on the stand in front of everybody. This is done by a meeting with either the friend of the court, which is kind of like the arm of the family court that helps address custody and divorce parenting time issues, or the judge himself. And that meeting is done with neither parent present. And the only thing that judge or friend of the court will tell you is whether or not they're taking into account what that child has told them in making their decision. They won't say what the child said or who they picked or anything like that. They will just put on the record whether or not they took it into consideration. Okay. Number 10, willingness and ability of each of the parties to facilitate and encourage a close and continuing parent-child relationship between the child and the other parent. Okay. Very important. This is, can you set aside your venom, your disdain, your hatred at some points for your ex in order to facilitate your child still having a good relationship with that ex? This is where you're going to get burned if you are coming off as spiteful or angry and you can't stop making snide comments about your ex in front of your child, because it will get back to the ex and you will have to face the music in front of the judge. You gotta put on a good face for your child. And like we tell our clients, you gotta care more about your child than you hate your ex, right? Like, care more about how much you care about your child than how much you can't stand your ex. Do it for your kids. Number 11, big one, domestic violence, regardless of whether the violence was directed against or witnessed by the child. If there's any incidents of domestic violence in the home, or a pattern of domestic violence, whether it's verbal or physical or both, even if the kids aren't around for it, that is a huge, huge, huge red flag to judges, because if you are going to have this child in your custody and care the majority of this child's waking hours, the court wants to make sure that you aren't going to turn your venom to the child if your ex is out of the picture, where if your ex was the target before that. Number 12, this is the catch-all. Any other factor. Okay, well, what does that mean? Well, if there's a child with special needs, like a very special medical problem or a learning disability, and one parent is more equipped to deal with it than the other, that will be considered. If either parent has threatened to kidnap the child or actually taken the child and not returned the child when they had agreed to, even if there's no court order in place, and that's like the big game people play, right? Like, well, there's not an order, so we can both take the child. And I know I said I'd have him back at 5, but now I don't feel like it. I'm just going to turn off my phone and not answer it. Don't play those games, because it will come back to haunt you with the judge. And again, the same thing with like parenting time or custody. Like, if you say you're going to have your child back, take your child back. And are there other children, whether part of this case or not? Again, this is where those stepchildren, half siblings, significant others' kids come into play. Significant others are new spouses and their relationship with the child. If your child doesn't get along with your new spouse or significant other, it is going to come back negatively on you. And no matter how much you try to sugarcoat it, the kid is going to make it clear that it's not a good relationship, and you're going to have to find a way around it. Either you separate from that person until the child is ready to handle that person in their life, or when you have the child in your care, that person's not in the home, so that there's not that negative relationship there. And again, is there an issue whether there's 2 or more children, separating them from the home? So with that, I'm going to stop screen sharing for a second. I obviously was not looking at any of the comments, but if there's any comments that you guys, if you want to shoot questions, a couple other things as far as custody cases go, there's a whole gamut of things, right? So obviously we talked about divorce and post-judgment, but just establishing your paternity of a child, each state is a bit different. And in Michigan, the rules have changed a few times over the years, but in general, there are time limits where if you believe that you are the parent of this child, you better not sit on your rights. You've got to take action, file something through the friend of the court or the circuit court to say, I think I'm the father of this child. I want to do a paternity test. And if you get that ball rolling, the court will assist you with getting the DNA test and getting an order so that the mother of the child makes the child and herself available so that you can make sure that this child is in fact yours. And if the child is yours, start paying support, get an order where you can see the child. In Michigan, if you are not married to the person that you have your child with, it is presumed that the mother has sole physical and sole legal custody of the child. Now, legal custody is the decision-making type ability, what medical care that child's going to get, where they're going to live, those sorts of things. Whereas the physical custody is just what it sounds like, who has that child physically in their care at any given time. And if you are the biological parent of that child, you have to take action through the court unless you and the other parent get along and you can sign a stipulated order in order to have something that is enforceable through the court. I know it's really frustrating for parents. If you see, and most of the time it's dads, just because they're the ones that don't get that presumed physical custody and legal custody if they're not married. And you can't just wait for somebody to come to your door and be like, hey, you should fill out these papers. Most of the court systems have some pro-per packets or information that they can give you so that you can try to fill it out and get started. There's also, in Michigan, we have West Michigan Legal Aid, which is a low cost or no cost legal services for people that qualify. And I would imagine that most states have that sort of option for pro bono work. If you're married and you have children, it's presumed that mom and dad each have shared authority, legal and physical custody. That's where it gets sticky when people separate, because they play that game of, well, there is no order in place, so I'm taking the kids, I'm enrolling them in this school. And then the parent takes them the next week and says, well, now I'm re-enrolling them in this school. Again, those petty games are only going to come back to haunt you. You really want to try to be the bigger person and work with your ex, even if it seems like they're acting crazy. Try to find some middle ground for the sake of your kids, and that will certainly look better for you in front of the judge when you get there. I think that's probably it. Okay. Well, guys, it's been really fun, and hopefully this video helps some people. Probably not so much most of you that are watching, because I don't think a lot of you are from Michigan, but obviously it will be posted on my page. If you have somebody that's going through a custody or divorce action, it's always wise to do your research, do your homework. It's a half-hour video. Send it to them, have them watch it, and it should give them some good tips. Again, preparation is key. Before you ever walk into your attorney's office, if you have notes written down, or you have pictures, or you have text messages outlining each of these factors and how they might weigh in your favor, bring them with you to your attorney's appointment. And that way it kind of narrows down the areas, so you're not kind of like shooting in the dark trying to figure out what you should tell your attorney. All right. Again, thank you all. I appreciate all of the support, and I look forward to seeing you guys in the future. And if you've got ideas for videos, let me know. You can always like, share, subscribe, and, come back next time. Thanks, everybody.